seminar. And unfortunately, our new seminar chair, Bjorn Beneke, could not be here. So the task of introducing our speaker falls to me. So today we've got Christopher Schwartz, who comes to us from right here at York University. And I actually looked you up on LinkedIn. So just let me know if it's the wrong Christopher Schwartz, but the picture looks pretty good. So currently, Christopher is a commercialization manager here at York University, and he came to York by way of Texas A&M, an institution that I've actually collaborated with a number of times. For those of you who are wondering, I know many people on the line here have degrees in physics, and so does Christopher from back in the day as well. In addition to a degree, a master's program in physics entrepreneurship, and a master's in business administration. So today, Christopher is going to be talking to us about intellectual property for academic research, and really why it's important for us to know something about intellectual property and the work that we do here in TEPS and in your research. So without further ado, take it away, Christopher.
Thank you. All right. I have a lot of slides. There's a lot of information to go through. I'm used to taking questions during the talk. I don't know if that works in this particular format. So I'll try to leave some time for questions at the end. I work at Innovation York. We are the industry licensing office for York University. We do all of the business agreements and engagements with external companies and business interests. Specifically, I do commercialization, which are projects that I get to handpick where there's some sort of intellectual property that we develop before there's a commercial party interested. While industry engagement might be the other way around, where an industry player comes in and is looking to work on one of their intellectual properties in their own project. This is what I'm going to try to get through today. We're just going to sort of briefly explain what all the different types of intellectual property are, how they work. There are legal professionals that do this day in and day out. I am not one of them. I'm more of a business project manager. I consult these lawyers, I get their advice, and make the decisions. So there's only so much we can get through, and it's just trying to build some familiarity. And the reason why we do this is to avoid snafus. And this is something that was recently in the news, I think a week or two ago, where University of Waterloo, which has an intellectual property policy very similar to York, where inventors own their IP, has a disagreement with some of their former graduate students, where even though they own the IP that they create, sometimes there are contracts or agreements around that ownership that are precedent, they take precedent over that. And in the worst case scenario, there are legal challenges, and that's what we're trying to avoid. To get an understanding of intellectual property, it helps to kind of have a decent idea of what property rights are to start with. It's a very old concept that everyone deals with in the course of their life, but you might not have a clear understanding. Like, what exactly does it mean to have, or in this example, a deed to a piece of property? What rights does that give you? Does that mean that you get to mine it, that you get to collect the water from it, that you get to live there? Not necessarily the case. There might be laws that preempt that right. All the deed does is allows you to keep other people off your land. In the legal context, there's a criminal trespassing, which there isn't really a criminal analogy for that in intellectual property, but your property rights, your intellectual property rights, keep other people from sort of invading your intellectual property space, if that makes sense. So if you have a patent, it prevents other people from using those exact concepts that you've protected. And that's all it does. And it's important to note that just like real property, the boundaries of intellectual property can be ill-defined. A lot of times you'll have deeds that both claim the same strip of land between them, and it's up to the courts to sort that sort of thing out. And it's the same thing with intellectual property rights. Most of these are written in English words, at least the ones we work with, so there is room for interpretation and eventually negotiation by the courts. So even though you might have something that looks pretty solid on paper, like a patent, actually getting any value out of that only comes down to what you can get done in court. And that's a very difficult concept for people to understand, but it's going to be sort of pervasive throughout the rest of the talk. Okay, broadly speaking, intellectual property is an attempt to protect creative work. And there's a bunch of different reasons you'd want to do that, especially in an academic setting, to make sure you have credit. We use patents to try and build value in a research program. So if someone creates something of value, the patent prevents other people from copying that work directly, and then you're in a better position to form partnerships with people who want to deploy this technology into the market. These are the 4 types of intellectual property. There's a few sort of off smaller areas, but these are the 4 main types that if you have some idea of what they are, you'll be in a really good place. And we're going to go through each one individually in varying degrees of detail, spending most of the time on patents because they're actually fairly complicated and one of the stronger forms. During the course of the talk, it's helpful. It doesn't apply to everybody, but if you can think of how your research program translates into these types of intellectual property, that's useful. These are a short list that I'm not sure is fully representative of the things that might be developed in the course of your research. And you have to ask yourself, how do they translate? And this is the best sort of mapping that I could figure out. And hopefully this makes sense as we go through. Originally, I had this at the end of the presentation, and people asked me to bring it to the front just for the sake of clarity. But as you can see, there's some overlap, and there might be some difficulty in applying some of these. But
So I was wondering if I could ask you a question
Yeah.
right here in the middle.
absolutely.
So something that is really current in the publishing world is that many journals now will not permit you to publish unless you're also willing to give up data, algorithms, and other things in the trade secrets area.
Yeah.
So that seems to be part of, or moving towards being part of copyright.
Right. So you're sort of talking about that's actually sort of the license agreement that conveys that copyright, that conveys rights to the copyright. So this is an issue we have with intellectual property, where a lot of times a researcher will call everything that comes out of the research program, this is my intellectual property. My data is my intellectual property. And I get what they mean, but at the same time, there's the legal definition of intellectual property, which is this government-issued property that you can allow other people to log off. And what we're going to find out is that unlike a publication, which can be copyright, data cannot. So if your data gets out there and someone else uses your data, there's no protection on that by itself. So what that journal is doing when they require you to submit the data with the publications, that's just another term in the contract so that they can, support their end. But it's more of the action of you giving them the data than you giving them rights to the data.
Okay, so that's interesting. So in order to get the copyright on your publication, you have to willingly give up any rights that you have on your data and your algorithms, your code. Right.
So the interesting thing about copyright is it's the protected ones offered, right? So as soon as you write that paper, and every draft of the paper you have going up to that, you have a copyright on it. So the publishing company does not have a right to copy the work unless you give them that permission. Academic publication is sort of even when you're publishing a book, there's an agreement there where they agree to give you a certain amount of money, and then they get the rights to use your copyright. You retain ownership for the most part, or in some cases it can be sold, but you can retain ownership, like with an academic paper, but they have the sole right to publish it. So it's that trade-off there of, yes, I want you to publish it, And in an academic circle, you're not really getting much in return other than that. So I guess they're just making the deal less and less appetizing. Okay. But that's the nature of copyright, is it protects your creative work, which in an academic sense is how you constructed the words on the paper. It doesn't protect the underlying concepts, whether they be discoveries or methods or inventions. Nothing structure, nothing purpose, nothing function, all form. That makes sense. So just to be clear, if you include data, algorithms, formulas, none of that is protected. It's all words, creatively written English or whatever language you're writing in. So an example of this is say Tinder. I don't know when Tinder came out, like a decade ago, maybe more. But their obvious best feature was swiping left or swiping right. And within a few years, there were dozens, if not hundreds, of apps that had swipe left, swipe right sort of features, right? That was an innovation that, even though it was encoded in software, which can be copyright, there was no way of protecting that function. So OkCupid could easily make an app that copies that, and we'd have no copyright violation there. Similarly, if Tinder reverse engineered OkCupid algorithm for making matches and employed it on their website, again, there'd be no way that OkCupid could get them for any sort of copyright or even any intellectual property. Also, there are fair use exceptions. So that includes, for some reason it's cut off on the screen, but that includes research uses, citations, scholarly, anything that you might do with the source, as long, I'm not even sure you have to, if you properly cite it, there's absolutely no copyright violation, and anyone who tells you differently, but there is, we've talked a little bit about plagiarism, right? So obviously you can't copy someone else's work directly. That's some sort of violation at the university level for sure, but there's also eventually a copyright violation. And where that copyright violation starts and where similarity is a little bit negotiable. So, for example, if I wrote a book about a wizard going to a wizard high school, like obviously that's been done before, but that concept I can copy. But if the main character is named Harry Potter, that there's sort of a smell test that only judges can really interpret. So on the right here are two photos that were taken by different photographers, and the bottom one, I believe, came second, and they were sued by the person at the top, and the UK court decided that they were too similar and it constituted infringement. So, we can negotiate about it, but it really just comes down to what the court thinks at the preponderance of the evidence. We talked a bit about ownership. The picture on the right is a good example of these macaques were trained to use a camera, and they apparently liked the appearance of their image in the lens. So this macaque took a picture of himself. And then PETA sued to say that the ownership belonged to the macaque because copyright ownership belongs to the creator. So this was a legal test case about animal rights more than copyright, but it's just an example of whoever creates the work owns copyright. So the exception is work for hire. If someone specifically hires you to make a piece of software and they know what it should look like, then they own that piece of software. Or if someone specifically asks you to write something technical or with limited amounts of creativity, that's a work for hire. It should probably also be in your contract. So I don't think these are not usually terms that you'll see in academic agreements. If you go work in a lab, you'll be the owner of the copyright. I'm sure there's some expectation that you publish with the group, but technically you own it. So that's copyright. Usually I take questions at this point. I don't know if anybody has anything specific that didn't make sense. I'll keep moving. Okay.
Well, I could ask about work for hire. So there are many pathways, right? So some people will say in academia, some will go into private industry, some will go into government. I imagine the work for hire type of thing, if that's showing up in contracts, occurs more in the private sector than in the other two.
Yes, absolutely. Everywhere that there's software, or you'll see a lot in, if you ever hire a photographer for like an event, any sort of event, especially weddings, take a look and see who owns the photos, because more often than not, it's photographers now that claim ownership of the photos, and they give you a license to your own wedding photos. Even though you've hired them for that explicit purpose, they make it the other way. So
check the fine print.
yeah.
And I know at York that graduate students can't actually give up the rights to the work that they do. Is that the same at most universities, or is York somewhat unusual in that?
What do you mean they can't?
So we're told when we enter into a granting agreement, for instance, with a company, that we can't give, if grad students are involved, the grad students cannot give up their intellectual property to the company.
So I would say that's not true in totality at all.
Okay.
By default, everybody owns their own IP, whether it's patentable or copyright. And we do have many agreements that give companies, it's very common to have agreements that give companies the results of a research project prospectively before any of the work's done. Because of our interesting intellectual property policy, usually those graduate students need to sign on to the agreement in some facet to do an assignment of those rights. So there's a lot of contracting, and that's one of the themes I hope to have through this presentation, is that the students need to be up to date on what agreements you want them to enter and what agreements they're subject to when they start researching in a specific area. But it's entirely possible to assign the rights. Most licensing offices, I would hope, and agreements groups would not give away the right to publish in general, right? Because that's sort of anti-academic. And we're going to get to that in trade secrets, where, spoiler, universities don't have secrets, because that runs contrary to everything we do here.
Okay. But there is I imagine there's a variation in different institutions. So maybe some of the people on the line might be curious.
Right. So, like, I was at Texas A&M before this, and the policy is completely different, where the university owns everything, and anything that any benefits the researchers get from the intellectual property, it's a gift from the university, pretty much. It's the benefit of working there. And in that case, it makes things much simpler, where by default, we have everything in one place, and we can give it to the company if it seems appropriate. Here, you need to put agreements in ahead of time, and you need to make sure everybody who joins the project is up to date. Again, I would hope everyone tries to keep the academic freedom to publish. Very few limitations on that, as few as possible. Just very briefly, we're going to go over trade secrets. The best example is Coca-Cola, right? The formula Coca-Cola. There's probably some people out there in the factory who know the exact proportions of sugar to flavor to color to water. And it actually has been stolen, I believe. At one point, a few of the employees ran off with it, ran to the CEO of Pepsi. CEO of Pepsi called the FBI, and they were arrested. Because obviously Pepsi didn't want to copy Coke. But there is some value that you're trying to protect with these secrets that help you do business. And if you keep the secrets in a good condition, this is actually a strong limitation on your employees and the other people you work with more than anything else. Another example is Waymo, which is a Google company, had a bunch of their engineers go to Uber. And all of a sudden, Uber had some functionalities that Waymo thought were proprietary. So that became a lawsuit for $1 billion, and it was recently settled for $250 million, I want to say, or like 0.3% of Uber had to be handed over because they agreed that there was some sort of misappropriation of secrets. What we have at the university instead of secrets, we do occasionally have confidential information. If you have a sponsorship agreement with a company, a lot of times they want their own information. They'll provide you with some of their inner workings, maybe their business development plans, maybe something technical, and they don't want that shared. And the best practice is to keep that information well identified, labeling the paper confidential, and then having an agreement that explicitly says what you can and cannot do with it. And there are some students in some labs on this campus that may be subject to non-disclosure agreements and not know because their work falls under a very large grant, and they're a very junior researcher, and they just don't know the terms of the agreements. Most people don't know the terms of the agreements. And these agreements are binding. I mean, there have been more suits over non-disclosure agreements than, say, a non-compete clause. Like you might also see non-compete clauses which are very similar in nature, and those don't really get followed up with lawsuits. These do. So we might be working with graduate studies a little bit to figure out better language and better ways of disseminating this information. So that's secrets and confidential information. Questions? Trademarks. We should all have some familiarity with trademarks. They are the legal protections that make sure a consumer or someone in the market knows who they're doing business with. When you walk into a shop that has a Starbucks logo, you know what company is responsible for that coffee, and it's not an imitator, it's not someone tricking you, and that's the entire point of trademarks, and they work fairly well. The trademark itself can be a logo, it can be a picture. It's very common to just have word marks, just the name itself, which protects that combination of letters and or the graphic use of it. So if you look at the Microsoft Office, that's a very particular font with that particular capitalization. All of those icons are very clear representations of what the programs are, and you can identify them off the bat. This is an example of the 100 most recognizable trademarks in Canada. So as you can see, with the familiarity, they bring a lot of value to the brands. You can also have trademarks on the company as a whole or the products in general. The trademarks are not descriptive, so you can't just have you can't call your shoe the shoe or blue shoe. That would be too, it would bar too many of your potential competitors. Other languages don't count either. The interesting thing about trademarks is that you're only allowed to have a trademark if you're actually doing business, if there are consumers buying your products. I've had many, let's call them projects within the university where they wanted to get a trademark first step, before it was even a product, before it was a company. So like, we need to trademark this to protect it. And you just simply can't do that unless you're out in the market selling things. And this is the reason why you see Apple suing like a coffee shop in Finland that has an Apple logo out front. Obviously, they're in a different business, but there is a responsibility of the trademark owner to try and protect it. And if they don't try and protect it, it gets lost. Right? For example, Bayer created aspirin a long time ago, and now aspirin has become a generic term because it just became too common in use. And to the right, there are a few examples of some, well, not Nike, but the other three are non-traditional copyrights. Play-Doh recently got a copyright for the smell of Play-Doh, which they described in English terms as sort of cakey and sweet. And apparently, if someone tries to copy their exact scent, they would have the grounds to sue. I don't know how you do that. Texas A&M trademarks the color of their sports teams, and sports is the biggest business in Texas, I think. And then NBC has trademarked the chimes, the three sounds, because they use it correctly to do that as a trademark. That's trademarks. Any questions about trademarks? Okay. This is the difficult one. Patents. Exclusive right to make, sell, buy, use, export, import. That's everything that you would want to do with a product. Just checking the time. And this is an absolute monopoly for approximately 20 years. The purpose is to protect innovators and to make it public. So every single patent, after 18 months of the application, it doesn't even have to issue, is published. So that if someone is working on a new technology and they want this awesome protection for 20 years, they do have to make it public. so that other people can use that innovation to further the art. And that's really the initial reason for patents, was that a company couldn't invent a new way of spinning cotton and then keep it secret for 100 years and keep the rest of the world from progressing. Not like someone, although someone could easily invent it. There's a few different types, and I just want to clarify, there are design patents, which are less common. This is a classic example of the iPhone, Samsung. This was a lawsuit about a rectangle with curved edges. Yeah, 539 million was the final jury verdict. There was $1 billion jury verdict first. Yes, so design patents only for aesthetics, right? So you can have a design of a chair that has this particular shape to it that you find aesthetically pleasing. It does not protect functionality, much like the copyright. So Apple couldn't claim that having a phone with curved edges was better to hold, or the Coke bottle is better to hold. It's just more aesthetically pleasing. Any functionality is forbidden. They're called industrial designs in Canada, and they last 10 years, and design patents in the US, and they last 7. I've actually never dealt with one of these, ever. But as you can see, you can make a lot of money if you have a particular design for a product. There's plant patents, which we had a lot of at A&M. If you have a new species of plant, you can protect it. You're the only one who sells it for 20 years. You can make a lot of money off this too. But what we mostly talk about is utility patents, where we're protecting an invention. I'm going to read these out. New compositions of matter, including devices, systems, or methods, including processes. So it's actually a pretty broad category. You can fit most things into those areas. Again, this is a government-issued document, so you have to be able to describe it in English and have it awarded through the patent office of whatever country you're applying in. So here's the example. Is this a device, system, or method? If I wanted to combine a microwave with a rice cooker, let's say I'm using microwaves and I'm able to have perfect rice that much faster. Do you think that's a device, a system, or a method? Any guesses? Okay. In this example, it can be all three. It entirely depends on how you use the language, right? Each of these titles, each of these approaches to drafting the patent would be appropriate. Typically, we think of devices and compositions of matter as being stronger protection, because a method doesn't really describe, it's less descriptive, if that makes sense. If you have a couple different devices could go through the same method. But again, it's the lawyer's job, patent lawyer's job, to figure out the best way to approach describing the problem in a way that covers the ground. You should take a look at patents sometime if you haven't already. Just like Google Scholar, there's Google Patents, has pretty much every patent that's been published, and there are millions. They all have roughly the same structure. The claims are what's important. They contain the nature of the invention. They're usually 20 sentences, because 20 is what you get for free without extra cost, but they can be as few as 1. There's a specification, which reads a lot like a paper that describes it, and there has to be at least 1 drawing of the wireframe style. Usually there's several, and there can be flowcharts for software. The claims are what is actually litigated in a court, right? So if you think someone is infringing, you sue them on the exact wording of the claims and their interpretation. So when you're trying to describe your invention, you have to write these sentences so that they cover as much as they can, but still pass muster of a patent examiner. And this is a very difficult concept that takes some practice. So here's the example. I'm trying to describe a book, and I describe it as an apparatus consisting of printed pages, a binding, and a cover, right? I think that's a fairly decent description of what it is, and then I narrow it down a bit with these 2 dependent claims, and that's how they're written, where they refer to an earlier independent claim. where I specify specifically what the binding can be. So whether or not these are valid depends entirely on the patent examiner that comes through. We've got to make arguments, and I'll get into what the arguments are about. But is this descriptive enough? I couldn't tell you without looking at all the prior art. For example, they might not know what pages are. You know, if there's never been a book before, why would they know what pages are? You have to know what language they're familiar with. If I talk about binding consisting of strings, I haven't talked about how they're laced through the pages. I haven't talked about how that particular thing works. Does this also, so these claims are fairly broad, and maybe I did that on purpose because I also want to block magazines, right? Magazines are pages bound by a staple. Would this protect you from people who create magazines? Probably, you know, maybe. Again, the pages might be made out of another material, maybe not. So these are how language, the variability of language affects what you're actually patenting. So on the left is an example of a patent we actually filed here. This is one half of the first claim. So it's way too long. I'm going to be the first to admit it, but we used several words that have specific meanings in the patent. So for example, fluidic communication is just water under pressure, right? Like you put water in one end, it comes out the other. I forget what that property even is, but they have a specific term for it, fluidic communication. External flow means, our paper just had the word pump, but we wanted to protect other ways of putting water into the channel. So you could have fed water in a few different ways, and this, in theory, protects you from all of them. So that's why we hire patent examiners who look at or patent agents who look at the previous work, find out exactly how they describe it. Just like in an academic journal, there's a certain vocabulary that they use. And I am not an expert in any of the areas that we apply for, but our patent attorneys have to be. And another example of a type of patent is a Marcouche claim, where it works well for chemistry, where you can just call out entire sets and kind of make them swappable. So do claims kind of make sense in general? Prosecution is a lengthy process and can be expensive if you have a lawyer doing it. All in all, it takes between 4 and 8 years usually to get a patent issued from the beginning to the end. We usually stretch that out in hopes that someone else will pay for it before it's issued, like an external company. But the process consists of a bit of waiting and then having an examiner looking at it, them issuing rejections, and there is almost always a rejection, almost always. And then you can respond to it by arguing against it, amending what you're offering, or trying to work around it. They're rejected on these 4 categories. This is what your patent has to be issued. We're going to go through each one. Useful. Everything is useful. Never seen an objection based on useful, except for perpetual motion machines, which are actually allowed in England for no particular reason. Embodied. This one is important that you describe one and only one invention. So sometimes you have just too much material. You'll have a device and a process, and sometimes the examiner will ask you to split those up. You don't always know this ahead of time, but it's something you can work through. Also, it has to be well described in the words that we're talking about, but it does not have to be proven at all, or tested, or built. So we've had patents of, for example, nuclear reactors. Designs of nuclear reactors that have never been built. They're fully issued patents. They can be treated just like that, where they're bought, sold, traded, but the device was never tested. Occasionally, they will try to say that this doesn't work because there's a black box, there's a missing component, it doesn't make sense as a complete system. And that's usually the objection you get with embodied, is someone skips something, or you use the wrong term. I've seen something like communication means used in electronics, and they're like, we don't know what that term is, so therefore this is a black box, therefore you're rejected in terms of embodied. It has to be novel. So that means nobody else has ever published it before in any sort of publication. And that means academic publications or patents or even trade shows. Or I have had a patent rejected because someone mentioned the concept in the future work part of a thesis. So then the examiners will look. They'll definitely look at everything you've ever published, everything that your group has ever published, and they will try to find examples of where you've used this before. This obviously doesn't extend to private conversations, which means something like this, where it's invite only of a select group. That is a private conversation. But something like a poster in the hallway, this building isn't on lockdown. That's technically a public disclosure. So once it's up there, it's out. Your own prior art, this is a complicated thing that we're going to go through a bit. Your own prior art counts against you. So if you publish something and then try to patent the next day, there's no way to do that in most countries. The US and Canada are an exception, along with about 12 others, but everything in the EU is gone immediately. So I try to work with the faculty who I know are working on something to get a patent application in process before that publication comes out. So I've had someone ask, if novelty is as big a bar as you make it, how could someone patent a car? I mean, this was the first patent on a car, I think it was 1895. It's like, well, someone patents a car, then GM can never have another patent again because the car's already been patented. And the truth is, you can't patent a car again. No one can ever patent a car again. That patent is expired. Don't try. But there are components of a car which can be patented. For example, if you have a new form of a seatbelt, it's a much smaller portion, but it's a very useful patent. And usually you don't see patents for entire systems like that, just individual components. Part of that embodied is that you get it down to one invention, which is one stroke of brilliance, right? And patenting the whole car would obviously not be a single inventive act. Okay, this is the priority example we're talking about. So in this case, someone at York invented it. Then someone else at a university who apparently invented it some other time, filed a patent. Then we published the paper, then they published the paper, and then this should say patent. The last one should say we try to patent it. In this case, because they filed the patent first, even though we invented it first, even if we published it first, well, not if we published it, even though we invented it first, the fact that they filed the patent first means that they have priority, and they would be the only ones who can patent. In this case, if the two sides invent it at the same time, and then we publish a paper, even though they filed the patent first, they would not be able to get that patent because we have publicly disclosed it. And then since our patent happens within 1 year of that publication, we actually could pursue it in the US and Canada, Australia, Japan, and there's a few other countries that allow that. Okay, the last metric for determining whether a patent is going to be accepted is obviousness. So this one is difficult because it's super subjective. Would someone who knows this art, someone who works, an expert, have anticipated this invention? And you'll find this a lot when the new work isn't that different from the previous, obviously. And this is something that you have to debate every single time with the examiner. And it's based on the specifications. If you have some data, this is where data actually helps. If you have some evidence that other people have said this won't work and you made it work, if other people have said it won't work this well and you make it work really well, these are tools you can use to convince the examiner. And it really is just about convincing a person. This is an actual patent that issued in the last 50 years. A patent examiner's kid, it was a teaching exercise, applied for a patent on a way to swing on a swing. I think everybody who's been on a swing would probably find this obvious, but somehow they convinced the examiner. This is the textbook case of a silly patent. This is from a comic, obviously. So would adding another handle to a mug be an invention, or would that be obvious? There was actually a Supreme Court case called Deere in like 1959, which said just adding components, existing components does not constitute a new invention. So I would say this is a no. Again, that might be up for debate. Okay, so this is what we're thinking about when we decide whether or not to file a patent. First of all, some things are banned, completely barred. And then it's just determining whether it's not obvious and novel enough, I guess. We don't really have time to get into specific cases, but just know that it varies based on the subject matter. For example, there were a lot of patents on business processes and computer methods in the 90s that have since been invalidated. They were issued, and then there were court cases that said, oh, we can't do that anymore. That was not really an invention. It's a bad idea. Same thing with medical diagnostics in the last decade or two. Just know that filing can get very complicated. It's a very bureaucratic process designed by lawyers. Every country you want a patent in, you have to apply individually. Even though there is a patent cooperation treaty that makes it easier, you still have to talk to patent examiners in every country in their own language. So if you want protection that ranges over several countries, it can get very complicated very fast. That's why we use lawyers that have good docketing software and expertise. Okay, so when it comes to patents and intellectual property in general, there are some good lab practices and there are some bad lab practices. Keeping records is always good. It used to be first to file, which means, or it used to be first to invent, which means if you had it written down in your lab notebook that you invented something on X day, that was the priority. And even if someone else published, you would beat them out. That's no longer the case. But you still need the good records to build strong patent applications and to protect your work in case someone claims infringement. We've talked about this a bit, but a lot of researchers on campus don't know the terms of the agreements that they're being funded under. And that can create problems, either misappropriating information or can end in a lawsuit like Stalin's, like the Waterloo example from the beginning. This is why I really hope if you have any interest or if you have something that might potentially be commercializable, that you come talk to our office. We do a lot of background work at the very beginning to determine who are the inventors, what obligations are there, and to sort it out and make it much clearer. Also do it before publishing because obviously all the patent rights are lost. And then the decision we'll make is always based on cost benefit. Those patents can run 20 to 30,000 per country. So even though IBM files hundreds per year, they're spending a lot of money on that. So we have to have a business case there that will, in theory, earn money off that investment. And that's our motive for filing intellectual property. It's always a business case. Okay, how are we doing on time?
It's
There you go.
45.
So that is the briefest of overviews on intellectual property running through. It's very hard to speak about what individual labs should be doing as the subject matter, the nature of the work, and the work products can vary so much. Just try and be aware of the agreements you have and talk to someone external if you have interest. Talk to your licensing office, or there are people within your university that can help you. That's the point.
Thanks very much.
Thank you. Any other questions?
All right, let me see if I can open this up. All right, so how about we do this? We'll start at York here in the room, and then we'll go on to the line. So are there any questions from here in the room?
Yes. You gave the example of a swing. It's kind of like a silly patent.
Yeah.
And that was filed somewhat recently. So what's the benefit of doing that? Why would someone file that patent?
That specific case was a patent agent or patent attorney that was just playing around for fun. Like,
It was just a goof, or
it was that one was a trivial example one of a goof. But there were many cases, especially in the early 2000s, where people would file patents on computer-enabled things. You know, the 90s was like a gold rush, right? And so somebody in the 2000s would be like, wait a minute, no one ever patented a mouse. And they would file that. And then it would get issued for whatever reason. Maybe the examiner wasn't good, maybe they made really convincing arguments. And then they would try and patent troll. And you would sue a company, and the company would have to prove that, yes, there were mice around in the 90s. And it just creates difficulty. So, I mean, anywhere you have a patent, there's the potential to, you know, so either patent troll or sue somebody, even if it's not your business.
So I think something that's of interest when we work with companies is licensing, right? This idea of, you know, you work with the company being able to maintain the ability to hold on to the IP generated within your lab, you know, in the future, so the company can't come back and say, well, thanks very much for this, and by the way, you can't use this in your lab anymore without paying us.
So, right. In our research agreements, we always have keep the rights to use for non-commercial and academic purposes. Right? Always, 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 and it would hopefully not be approved otherwise. I do have a hand in some commercialization agreements when they become non-standard. I'm sort of advised on those. Whether or not we keep the intellectual property that comes up from the project really depends on the nature and the scope of the work. But I'm very keen to protect what's called the background intellectual property. You probably don't know about that, but that's all of the work you did before this, whether or not it was in a patent or in a copyright already, that gets integrated into the new project. So if you have a bad background intellectual property term, you can find that this new project, no matter what the size, entangles up your old work so that you can't use it with other companies. And that's what we try to avoid more than anything, is keeping that from getting entangled. But none of our agreements should ever limit you from exercising the work. The problem is if you create something really successful, the company runs away with it, then they become the vendor, and then they charge you for as a product.
An interesting related question. So, what if the company never signs an IP agreement with you? Sometimes you're chasing them down for a long period of time.
Absolutely. So I think every time there's funding coming on campus, there should be an agreement, but often there aren't intellectual property terms along with the agreement. So in that case, everything defaults to, first of all, the laws of Canada and the policies of the university, in that order, obviously. The laws on invention are very clear that, you know, if you created it, you owned it, right? So I'll see a lot of researchers sort of negotiating on joint ownership or joint invention. Like joint ownership is one thing. You can give away your property whenever you want, but they'll try to negotiate on joint inventorship with a company where you don't know, right? Because there's a process to inventing, and it is possible for two people to invent a single invention, but you're not supposed to know when it happens or who contributes ahead of time. That's unknowable. So if there's nothing written, if there's nothing tacit, then it's just you look back at who actually invented it. Those people own it. If it's shared between the two institutions, there are laws for that. Where in Canada you have to make decisions together. Everywhere else in the world you can make decisions separately. People have interests.
Okay. Yeah, it's interesting to know that, because I know in our postdoc contracts now there's IP language, and as the person doing postdoc hiring, I know I have three choices.
Yes.
One, I can say that all of their inventions are really my inventions. I can say all of their inventions are their inventions. Or my favorite clause, we'll discuss it like adults and figure it out.
Right. Which, yeah, I find a lot of people trying to put that language into contracts, but hopefully that's the default, right? Like, so, yeah, I've seen that particular agreement, and you can have we need to be very clear that while you can say all of their inventions are my inventions, that means I own all of their inventions. But if they invented it, they need to be listed as an inventor in a patent. copyright. Otherwise, that will invalidate your patent. But it can come back to bite you. So it has to be very clear that the creative, whoever created it gets the credit, even if you own it and exploit it yourself. So.
All right. Well, let's go to the line. So maybe what I'll do is I'll do this geographically. Yeah, that's okay. Thank you, Celia, for that. So if we start from the east and go west, so is there anyone at Montreal, sorry, at McGill with a question? Okay, hearing none, I'll go on to Université de Montréal. Anyone there? All right. University of Toronto?
Presentation. I don't really have any questions.
Hello? Thought I heard someone.
Yeah, it was Kim.
Oh, hi, Kim.
Yep, I don't have any questions. Just say thank you to Chris for the presentation.
You're welcome. Anyone from York who is not at PSC 422? All right, I don't think so. I think we have just somebody. How about the University of Western Ontario? Okay, we'll jump a few time zones and we'll go to the University of British Columbia.
A few.
Hi, Brett.
Hi. I don't know if this factors into it too much, but there is a sort of a slight difference between a university and some other company in that, you know, a lot of us are funded to do research that's public money, and in some sense there's an expectation that the results of public money will be publicly available and not enrich the coffers of somebody else.
Right.
I think that's encompassed by what you stated, that you fight to keep all of the rights for research and things like that. But are there other aspects of that about how it's different for a university than some other corporation?
Absolutely. That's actually a sort of a tricky area. Again, in the US, there's the Bayh-Dole Act, which is actual law that started the whole tech transfer sort of movement in the late 80s. And in the US, if there is federal funding of the research, then all the disclosures have to be reported back to the issuing agency. So they're mandated to make sure that the government knows of the benefits of that work. And then the university is mandated to commercialize it independently. Whether or not that was the right approach, I don't know. But there have been many universities that are, for example, Innovation York is not self-sustaining in terms of commercialization yet. Usually, successful commercialization projects are unicorns. For example, at A&M, we had $10 million in annual revenue off 2 projects out of over 4,000 that were disclosed in the 20-year history. So yeah, a corporation has the requirement of sort of benefiting itself, while the university doesn't really have that capability with all the research we have. Usually we have to have external partners, and we can sort of debate whether or not the royalties, the rates we get, the ownership in the company are sufficient compensation. I definitely can't answer that question, but it is a chief concern. Especially with pharmaceuticals, when you have you know, a pharmaceutical that's developed through public funding, then is licensed to a company, and then has an exorbitant price. People think that there's double dipping going on, and to some degree that's correct, and to another degree that money is flowing back to the university. Whether or not it's enough, I don't know.
Well, in that particular example, the taxpayers might say, we funded the research, so we shouldn't be getting shafted to, but okay. So A specific example related to what you're saying was data. So did I understand you're saying you can't copy, you can't hold on to data even if you wish?
That you can hold on to it by keeping it secret, if that makes sense. So if you publish your data to the internet and say, hey, no one copy this, that's not really going to work. People have tried to copyright, the best example, there were court cases on phone books. Someone tried to copyright the phone book. And the court said this is not a creative work. It just simply doesn't meet the level of creativity. So if you've just recorded data, that's not a person creating something. So the only way to keep your data protected is to not give it into not put it into the hands of people that would run off with it, if that makes sense.
Yeah, okay.
There's no other protection really.
Yeah, I think I might have been the one who sort of, invoked this particular question, where more and more journals now, in order to, generate the copyright or accept the publishing of a particular paper, demand that things that previously were kept secret, like what your data set or the code that you use to generate your results or your methods, that these now have to be placed in the public domain or at least placed in the journal in order for them to even consider publishing the paper.
Oh, so they don't require it goes into the hand of the journal. They'll accept it if it's public.
Yeah, that's right. And you see that a lot of times. I know Springer's like that, Wiley's like that, that it doesn't need to be kept with them. It just needs to be somewhere public and accessible.
Okay. Thank you.
Thank you. All right. Anyone else from the University of British Columbia? University of Victoria. All right, and then we'll just take the diffuse internet. So if you don't fall into any of the other categories I've mentioned, but you have a question. All right, well, do we have one? No. All right, so I think at this point, let's thank our speaker one more time. So if you were attached to this call, I believe that Anna has a record of you having been here. As you saw with the email this morning, NSERC wants us to have a record that all funded trainees have seen all of these. So if you know anyone who is a funded trainee who's not here, we're going to send out a link to this later on so that it can be downloaded and viewed afterwards. And the only requirement is that if you weren't here in person, that you send Anna at the TEPS at yorku.ca an email just to confirm, so we have the documentation for NSERC, that they have seen this particular seminar. So thanks once again, Chris, and we'll meet here again for the next seminar. Thanks, everyone.